Hello, good afternoon. This is Erick Widman from Passage Immigration Law. We're very glad you joined us for another live Q&A about immigration law, where I can answer your questions that you've already submitted to us online. Whenever you have a question, simply email it over to us or submit it on social media. And our marketing coordinator compiles that for me. And then I get to take a look and give you some insights to your questions. So we've got a number of great questions today. The first one is, what is a 245I adjustment of status, and can it help me? That is quite intriguing, and that number sounds very technical. That refers to a part of the Immigration Law Code, the Immigration and Nationality Act. Section 245I is an older law, an older statute that was passed way back in the 90s, but it still has relevance today if someone had filed a petition for you prior to April of 2001. So it can help someone get a green card if you're lucky enough, over 20 years ago, someone had filed a petition for you and it is a valid, legitimate petition that would help you. For example, a family member, a sibling, a parent, a spouse had filed a petition for you, and then you have another way to adjust status, for example, through a US citizen spouse. You're able to overcome an unlawful presence issue where many people would need a waiver. So for example, if you're undocumented and you enter the US unlawfully back in the 90s, you normally would need a waiver after you've accrued unlawful presence of over 6 months. And you would need a waiver or a way to overcome that if you trigger a 3 or 10-year bar. Very complicated, yes. But for many people who have a petition under 245I that was filed before 2001, April 2001, they are able to use that existing petition, according to the law, to overcome the need for a waiver. And you don't have to do an I-601 or I-601A waiver, leave the US, and come back in. So if you qualify for a 245I adjustment, you're hitting the jackpot in many ways. And we love seeing those. Immigration lawyers love seeing those because it saves a huge amount of time and your money to be able to proceed with that rather than a waiver. Also, if you might have read about a 245A adjustment of status, that is a standard, straightforward, immediate relative adjustment of status. And when you're an immediate relative, there's a visa number immediately available, and you don't have to wait an extra long time like you do for a preference category. Okay, let's move on to the next question. Will multiple entries into the US keep me from getting a green card because of the permanent bar? Yes, that is a scary sounding penalty, and it has serious consequences for those who are applying for a green card. The permanent bar is worse than the 3 or 10-year bar, which keep an applicant for adjustment of status or for a green card through consular processing. They keep you from being able to qualify for your immigrant visa because the law says you have unlawful presence, you triggered this bar, you're unable to proceed and get a immigrant visa from a US consulate until you've waited 3 or 10 years after leaving the US. So the bar is triggered when you leave the United States. And many waivers require you to leave the United States in order, like an I-601A, to qualify for an immigrant visa, and then you come back in on that. The permanent bar is worse than the 3 or 10-year bar because there's no waiver available like there are for the 3 and 10-year bars. So a I-601A waiver can help with a 3 or 10-year bar, but the permanent bar is it's scary and it has worse consequences because you have to wait, no matter what, the full 10 years outside the United States. What triggers the permanent bar? So the first thing that has to happen to give you this bad outcome is that you've overstayed your visa, you've accrued over a year of unlawful presence within the United States. You leave, you trigger the 10-year bar, but then you try to re-enter. So, or you might have been deported after being in the US and you try to re-enter, that can also trigger the permanent bar, and then you're required to wait out 10 years outside the United States before you're eligible to come back in. And if there's a criminal issue involved, you'll often need a 212. It's not a waiver, but a 212 document is an exception similar to a waiver. But you got to file that 212 if you have a criminal background too. Okay, good questions, everybody. Next question is more information on citizenship and the possibility of dual citizenship, please. Well, citizenship, becoming a US citizen through naturalization is always a great idea. This week, was it Wednesday? No, yesterday, I had 3 naturalization interviews in a row. They all got approved, very thankful, but I love when they don't conflict with each other. Sometimes immigration lawyers, we have to cover for one another when USCIS doubles up on the scheduling. I wish they would figure that out better. Liaisons have mentioned that to them, but they still double schedule many immigration attorneys. So I had 3 naturalization interviews. Highly recommend that as an option for you to secure your status for the long term. Become a citizen if you're eligible. And you asked about dual citizenship. If you're from one of many countries around the world that they tolerate dual citizenship, like the UK or Hungary or Australia, Germany, if you file the correct paperwork, that's possible there too. You can keep citizenship from both countries and be a dual citizen. And that allows you to travel the world very smoothly, very freely, more so than if you were just a citizen of a single country. It's the best of both worlds. My kids are dual citizens of the US and Hungary, and I'm excited. They're still in junior high at this point, but they could study and work and travel long term in the EU. So the dual citizenship option is a great one to pursue. Definitely sign up for US naturalization if you have the ability to do so. Okay. Next question. Question is about EB2 national interest waiver. Hello, I think I'm qualified for the national interest waiver and I need a lawyer to find the way and get more details. That is exciting. The national interest waiver allows you to avoid the perm process and all the extra hoops that go along with that. I highly recommend that you provide your resume and background to good law firms like ours and ask for an assessment. Do you think that I would qualify for a national interest waiver? They're tough to get approved. So rather than going into the criteria about that, I would just say you should definitely look into it, but recognize it is hard to get those approved, and ask a qualified immigration lawyer after looking at your specific case if you qualify, because it's hard to know just based upon facts and criteria on the USCIS website, for example, if you qualify. Thank you so much for joining us. I'm going to keep doing this weekly. We appreciate your questions and hope it's helpful. Let us know if you have any other questions, and take care.